Szanowni Państwo, jestem niezwykle zaszczycony Państwa obecnością. Serdecznie witam na wicerektora, pana profesora Andrzeja Wojtylę. Serdecznie witam naszego gościa, najwybitniejszego kaliszanina, profesora Theodora Merona. Szanowni Państwo, oklaski jeszcze raz.
Bardzo wszystkim dziękuję.
Serdecznie witam kadrę nauczycieli akademickich nowo powstałego Wydziału Prawa Uniwersytetu Kaliskiego wraz z jego dziekanem, profesorem Markiem Szewczykiem. Cieszę się, drodzy studenci Wydziału Prawa, że skorzystaliście z tak wspaniałej okazji. Takie spotkania zdarzają się niekiedy tylko raz w życiu. Jest to okazja do tego, żeby się zainspirować i żeby się zainspirować niezwykłą drogą, niezwykłym dorobkiem, niezwykłą postacią profesora. To wielka rzecz, Szanowni Państwo, że macie okazję tu, w murach swojej uczelni, mieć spotkanie z tak wybitną postacią. Proszę to docenić i mocno tak zakorzenić się w pamięci właśnie tę chwilę, bo myślę, że mogą z Państwem pozostać przez długie, długie lata. Panie rektorze?
Ja tylko krótko powiem. Bardzo witam serdecznie pana profesora Merona. Ja chciałbym przypomnieć, że pan profesor jest pierwszym naszym doktorem honoris causa, także jest w naszej społeczności akademickiej i jest naszym członkiem. Także jest waszym kolegą. Z panem profesorem jest również pani doktor Ewa Sałkiewicz-Munerlin. Ja tylko powiem krótko, bo jak ja studiowałem na Uniwersytecie w Georgetown w Waszyngtonie, to ja była tam konsulem polskim i tak się poznaliśmy. Wcześniej, jak wiem, była również konsulem przy Stolicy Apostolskiej. Potem pracowała w Ministerstwie Spraw Zagranicznych. Teraz pracuje w naszej uczelni. Ja chciałbym, żeby pani doktor trochę przybliżyła nam sylwetkę profesora Merona i swoją również. Ja tylko mówię to, co całego życiorysu pani doktor nie zna. Potem chciałbym, żeby pan profesor krótko powiedział o swoim życiorysie. No i nie będziemy długo, bo mamy już o 11:00 rozpoczynamy uroczystość inauguracyjną. No i chciałbym, żebyście zadali parę pytań panu profesorowi. Tak uzgodniliśmy. Może tak być, tak? Proszę bardzo, pani doktor.
Dzień dobry Państwu. Przepraszam, że siedzę, ale trochę mam problem z nogą, więc powiem dwóch słowach o sobie, ponieważ doktor powiedział, żeby coś powiedzieć. Ja oczywiście nie będę mówić długo, ale po profesorze dłużej, bo wiadomo, ma większe osiągnięcia. Ja zaczęłam pracę naukową na UJ-cie, który skończyłam dawno temu, potem doktorat, potem były zmiany w Polsce, więc postanowiłam też zmienić coś i przeniosłam się do MSZ-u. Oczywiście nie tak sobie jak teraz się robi, tylko był egzamin, dostałam przyjęte i tak dalej. No i tak pan rektor wspomniał, pierwszą moją placówką była ambasada przy Stolicy Apostolskiej. To było dawno temu, 93-4, kiedy nasz papież był tam, czyli Jan Paweł II. Wjechałam tam jako pierwszy sekretarz. Ci z Państwa, którzy oczywiście znają się na protokole dyplomatycznym, ale pewnie oczywiście są tacy, to wiedzą, że no, to jest taki stopień dyplomatyczny średni przypuśćmy. A potem się okazało, że ambasador był chory, no potem zmarł, no więc nomen zostałam księżem na Ferno i byłam tam rok. Potem z kolei przerwa, następnie jako konsul tu w Waszyngtonie, to właśnie miałam przyjemność poznać rektora. Do tej pory utrzymujemy kontakt przyjacielski. Było bardzo przyjemnie, tam z kolei byłam 4 lata. Tam poznał mojego męża, jest Amerykaninem, stąd drugiczne nazwiska. I teraz oczywiście miałam potem wykłady na różnych uniwersytetach, pomimo że pracowałam 27 lat w uniwersytecie non-stop. A potem z kolei po przejściu na emeryturę na moją prośbę właśnie tutaj zaczęłam wykłady. Natomiast jeśli chodzi o profesora Merona, oczywiście to znamy się bardzo dawno, jeśli chodzi o książki naukowe, bo nie znaliśmy się na początku osobiście, potem na podstawie publikacji. I jak profesor otrzymał tą wspaniałą, jako pierwszy doktorat honoris causa jeszcze Akademii, teraz Uniwersytetu, no i siedząc przy kolacji zaczęliśmy rozmawiać i okazało się, że żona profesora i moja najlepsza przyjaciółka, zresztą też profesor, bo to między nami profesorami mniej, a oczywiście, ale mówię o profesorze Maryna Spinelli, właśnie jest przyjaciółką żony profesora. No i oczywiście tak się tutaj spotkały nasze te losy. Jeśli chodzi o profesora, to oczywiście Państwo na pewno wiedzą, bo przeczytaliście Wikipedię, jak teraz to jest moda i w ogóle o jego osiągnięciach są tak duże, że to po prostu aż jak to się mówi, nie trzeba nawet mówić, ale powiem, a mianowicie no oczywiście jest kaliszaninem z urodzenia. Kiedy się urodził, to każdy może sprawdzić, nie powiem, bo trudno, że nie jest kobietą, ale to jest tajemnica. Natomiast jest o dużo młodszy duchem niż my wszyscy, a przynajmniej ja na pewno. No w każdym razie tak czy inaczej, trochę jak tu właśnie przeczytałam i rozmawialiśmy, oczywiście toute proportion gardée, ale chodzi o to, że była podobna taka nasza ta droga w tym sensie, że profesor najpierw zajmował się no też dyplomacją, ale oczywiście na wysokim szczeblu, bo był nawet ambasadorem Izraela w Kanadzie. To było w latach 71-75. No i potem oczywiście wielka kariera naukowa na różnych uniwersytetach, to już jest ich tak dużo, że nie wystarczyło czasu wymieniać. Natomiast to, co jest jeszcze tutaj bardzo ważne, to to, że od 2014 roku profesor Meron jest profesorem wizytującym Międzynarodowego Prawa Karnego na Uniwersytecie Oksfordzkim. I z tego oczywiście nie mówię, bo jest bardzo skromny, ale ja przeczytałam w internecie, że swoją pensję z Oksfordu przekazuje uniwersytetowi, co umożliwia utworzenie funduszu stażowego dla studentów Oksfordu. Tak przynajmniej było powiedziane w tym mechanizmie. Ostatnio profesor Meron jest doradcą, to jest tych ekspertów 6, prawda, bo napisali, że 8, ale 2 dodatkowych, tego szefa MTK, czyli Międzynarodowego Trybunału Karnego, Karima Khana, w sprawie przeciwko przywódcom Izraela i Hamasu. I w opinii, która została wydana przez ekspertów 20 maja tego roku, mówi się, że Palestyna, w tym Gaza, jest państwem w rozumieniu statutu MTK i przyjęła ona jurysdykcję Trybunału w przeciwieństwie do Izraela. To by było tyle w wielkim, ogromnym skrócie o oczywiście osiągnięciach i życiu naukowym profesora, a najlepiej może on opowiedzieć.
Well, it's such a pleasure to be with you this morning. When you are my age, the one thing which you enjoy more than anything else is being with students. And I very much enjoy having the possibility at my age still to be a professor in Oxford. And talking to students, being with them, gives me a lot of pleasure, and I learn a lot from them. And before we start on the subject, let me give you a little bit of advice from my experience. In your life, don't be afraid to change subjects, to change professions. If you do something which you don't enjoy, change. I myself have had at least 4 careers. Sometimes I can count them as 5. I was a diplomat. I was an advisor to 2 governments. First Israel, and then the United States, when I moved very many years ago to New York. I was and still am an academic in various universities. I spent much of my life at New York University in New York in the law faculty. I taught also at Harvard and at Berkeley, and I was also professor in Geneva. And then I was very lucky when I was completing my 20 years as a judge and president of the UN War Crimes Tribunals at The Hague, I was invited to Oxford because at that time, Oxford did not have on its program international criminal law. So they invited me to Oxford to start teaching international criminal law. It was my second visit to Oxford, because when I was still a professor at NYU, I was invited twice to that famous Oxford college called All Souls College, which is the only college in Oxford which does not have students. They only have senior academics who come and do research and write books. And then it was such a pleasure to return to Oxford again, and like so many temporary things in life, this became permanent, because I have just now ended my first decade in Oxford, which I am enjoying very much. The most important part of my life, I think, was my work as a judge. I must tell you, the reason how I became a judge, I was a professor and I was not an expert on international criminal law. But I was appointed by the US government to be a public member of the US delegation to the conference in Rome, which, as you know, adopted the statute of the International Criminal Court. And that was a great experience. And after that, after a period as a visiting professor at Berkeley and Harvard, I was invited to become the legal counselor on public international law to the US Department of State. And I was very, very lucky. And I think luck, in addition to talent and hard work, are very important in life. You need a little bit of luck. What happened during that period when I was in Washington is that the American judge, and by then I was American, was a woman, a very famous woman judge by the name of Patricia Wald. She was in the federal court in Washington, D.C. And her husband was not well in Washington. He did not go with her to The Hague. And she had to resign the post at The Hague and return to Washington to take care of her husband. And there was an opening for a judge. And I said to myself, nothing ventured, nothing gained. I will apply for the job. And the United States State Department takes judicial appointments very seriously. They had a committee, and the committee had 5 candidates, and I was lucky to be elected. And the first few months before I went to The Hague, you have to be elected nominated by a government, at that time approved by the UN Security Council, and then obtain the absolute majority in the General Assembly of the United Nations. And I made it in the first few months preparing for my job. I want to tell you, I read everything I could about international criminal law, because apart from my participation in Rome and my knowledge, which was theoretical, I felt that it would be a real, almost mission impossible to come to speed and become a real judge, a judge that has to decide about freedom or prison, and decide by applying the law and by applying the evidence, and never, ever, ever yielding to political pressure or to personal preferences. And so I became a judge at a very, very young age of 71. And to my amazement, 2 years after my election, my colleagues elected me as president of the court, which shows their judgment was very poor, I must tell you. And for the first 2 years, then I was re-elected. And eventually the one thing which I am really very, very proud of, that in my life, I had the record of appointments as president to United Nations War Crimes Tribunals. I had altogether, counting the various courts, 7 terms as president. So my 20 years at The Hague were mostly in leading the tribunal. And it's a very, very difficult job because you try to get consensus of judges. You know that what you are doing is not theoretical. You decide whether people may have to spend the entire life which remains to them in prison, or they would go free. And I always felt that international criminal justice is not about the result, namely conviction or acquittal. It is about justice, and it is about fairness, because it is about the process which must be objective, fair, which must be guided only by law and by evidence. No extraneous considerations, even if those considerations are desirable. So, for example, sometimes people say to you, you have to acquit this person or to convict him because that would be good for peace. But then the answer to that, you agree with that, it will be good for peace, and what can be more important than peace? But your job as a judge is not to be a politician. It's not to be a diplomat. It's not to be guided by general considerations, peace, reconciliation. It is only guided by the narrow mandate of applying international law and applying evidence and nothing else. So before opening the floor to the questions that you will no doubt have, I would like to tell you something about the achievements and the shortcomings of international criminal tribunals, which I have served for many years. So let me start by saying something about the challenges or the difficulties. So the first point I would like to make is that in contrast to Nuremberg, we do not have police powers. We cannot send a UN policeman to arrest somebody whom we would like to judge at The Hague. We depend completely on cooperation of states. Sometimes that cooperation is coming, often it is not coming. So, for example, when we started in the Yugoslavia Tribunal, in the first few years, the countries were not willing to deliver the accused to us to The Hague. And I remember during those years, it was before a judge, I wrote an editorial for a famous newspaper, Washington Post, expressing the concern that maybe we will have no one to judge because nobody will be sent to The Hague. And really what made the change was the fact that the big powers, Russia was not interested very much, and they were very much actually supporting the Serbs, so they were not too much interested in helping us, to say the minimum. But the United Kingdom, the United States, the European Union were very helpful, and they made it very clear to the countries which were established in the former Yugoslavia, Serbia, Croatia, Bosnia, that unless they are supporting the court and sending the accused to The Hague, arrest them, send them to The Hague, and help us with finding the evidence, they will not be given international support, and they will not be admitted to the European Union. And that made the difference. And Western intelligence services, French, American, British, helped us very much, helping our prosecutor in finding the location and the names of people who were responsible for the worst terrible crimes known to humanity: murder, ethnic cleansing in the case of Yugoslavia and later Rwanda, massive rapes of women, terrible things. And people started delivering to us the accused. I remember before Milosevic, who was president of Serbia, was delivered to the court. Before Mladic was delivered to the court, I would make, as president of the court, visits to Belgrade and ask them for cooperation. And I would see, for example, head of the military intelligence, and I could look him in the eyes, and I knew he will never help me. But eventually, international pressure helped, and we got some of the highest people in those countries as accused to The Hague, and we tried them. The trials were long, they were costly, but they were fair. And you may have noticed, for example, that the International Criminal Tribunal, as Professor Sarkiewicz mentioned, I am now advisor on international humanitarian law to the chief prosecutor of the ICC, that the prosecutor of the ICC has requested the court to issue arrest warrants both against Hamas leaders and against Israeli leaders, and that's how it should be. The International Criminal Tribunal, the UN War Crimes Tribunals, were established, as you know, under Chapter 7 of the UN Charter. This is the only part of the UN Charter which gives us, or the United Nations, the right to issue orders to states, not just to us, be nice to me, do something, you give an order. And in reality, the fact that we had this authority did not really help. States cooperated when they had interest in cooperating, and we need education of people of your generation, younger people, to make sure that international criminal justice, despite all the difficulties, will prevail and will be the dominant force. In the International Criminal Court, the power which is quasi-legislative, namely the right to adopt the rules of procedure and evidence, rests in the hands of assembly of state parties. In our tribunals, UN tribunals, the judges themselves, in their plenary, had this quasi-legislative power to adopt the rules of procedure, and I think we did quite a good job on that. One of the things that may be of interest to you is that we have judges coming from two main legal cultures. The common law culture developed in the Anglo-Saxon world, which is based on an adversarial system. Each party tries to produce evidence, and the judge fulfills a role a little bit like an arbiter in football, in soccer games. He does not intervene too much in the proceedings, it's left to the parties. And the civil law system, which is inquisitorial, where the prosecutor leads the process and the judges. And we had to develop some kind of a synergy, accommodation between these two legal cultures. And what we started almost totally from the common law system on the rules of procedure and other things. And over time, we maintain on the substance of the law, the common law adversarial system, but on procedure and evidence, we moved from the Anglo-Saxon system a lot to the civil law system, because civil law system proved to be much more effective. In management of the court, the judges have a much greater authority. Written evidence, which is very often allowed in civil law procedures and is not really allowed, generally speaking, in common law or in the Anglo-Saxon system. We allow it. Hearsay evidence, which is not allowed in common law, but it is allowed often in the civil law, we now allow it. And this, on procedure and on evidence, our system is to a very large extent the civil law system, which I believe you also have in Poland, correct? And we have increased the power of the judges to arrange to control and to manage the proceedings in the court. What about these were, I spoke mostly about the difficulties. What are what are the achievements? Well, one thing which is against the achievements is that still more than 1/2 of humanity is not bound by, did not accept the obligation to be a party of the International Criminal Court or other criminal tribunals. The big countries, the United States, Russia, India, China, Indonesia, and so on, have not accepted the jurisdiction of an international court, which is not good. Still, despite the fact that not all of our arrest warrants were respected, we managed to get into The Hague and to judge a number of very senior people, whom I have already mentioned: Karadzic, Mladic, Milosevic, the chief of Janjaweed in Darfur, who have committed a lot of killing of Africans and tremendous number of rapes. We now have at The Hague for trial the head of the Janjaweed. We have succeeded in giving fair trials to everybody. We have fleshed out and developed the criminal code, which was only skeletal or very abstract, very general in Nuremberg. We have developed a corpus of law on procedure and evidence. We brought about a revival of customary international law, and perhaps more important than anything else, norms of international humanitarian law were written as norms governing relations between states and between armies. We developed these general rules, transformed them into something which could be applied with the required degree of specificity in trials of individuals. And you need in international criminal law the possibility to have rules which are very detailed, very specific. Otherwise, the person who is accused could say, I did not know that this is a violation of international.